Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. This will be a video for the hometown crowd. We are talking about bad legislation coming out of Olympia. Now, normally, when we talk about bad legislation coming out of Olympia, it almost exclusively comes from one side of the aisle. Does that mean the other side is incapable of writing terrible legislation? No, it does not. And that's what we're going to be talking about today. We're going to be talking about a bill that is trying to address a real problem. I will acknowledge it is trying to address a real problem. The solution it has come up with is completely ludicrous and candidly an abomination of the Constitution, statutory and ethical duties on the behalf of lawyers. Don't believe me? I'll break it all down for you so that you guys can understand what this bill is trying to do. So today, let's spend a few minutes and let's talk about a very misguided GOP bill in Washington State. Okay, Washington, what we're talking about today is House Bill 1891. It is sponsored by 4 Republicans, okay? And they are Representative Jenny Graham, Representative Rob Chase, Representative Jim Walsh, one of my favorites, and Representative Suzanne Schmidt. This is a bill which is intended to address a serious problem that we do actually have here in Washington State, which is violent criminals going into the criminal justice system and then being released back out to society while their matters are pending, only for them to go out and shockingly continue to commit violent acts in their community. And it is a real problem. Now, what this bill wants to do is address or come up with a remedy for that. The problem for this bill is that whoever drafted it, and one of you 4 sponsors is going to have to own up to drafting this bill, because unfortunately you had no clue what the 6th Amendment actually requires of defense attorneys when representing individuals. You have no clue whatsoever of what is ethically obligated of attorneys when representing the accused, and you have no clue whatsoever what the rules of professional conduct require for attorneys representing the accused. Because if you did understand that, you would have never drafted this legislation. Let me give you the language of the bill itself, the part that's got Washington gun law all spun up here, so that you can understand what the bill would do. The bill reads as follows. Any person injured by an individual who was previously arrested for a violent offense and subsequently released from custody before trial for such offense as a result of the advocacy of their criminal defense counsel has a cause of action against such criminal defense counsel if... Okay, got news for you. Nobody is released because of the accomplishments of criminal defense counsel. They are released because of decisions that the judge made in weighing both sides of the argument. And we're going to break this down for the sponsors of the bill who clearly do not understand how the adversarial process works. But apparently, the defense attorney could be held liable for doing their job if the following occurred. A, the individual caused the injury after being released from custody. And B, the criminal defense counsel failed to adequately consider the risk of public harm that could result from the individual being released from custody. Please understand that in this 3-part equation, 2/3 of that equation are already mandated to look for that. Why? Because it's their job, not the defense counsel's job. But it gets worse than that, you see, because what does it mean for a defense attorney to adequately consider the risk to the public? Well, the bill reads, for purposes of this section, adequate consideration requires A, written and published assessment that analyzes 1, all known evidence about the individual's alleged violent offense, criminal records, and risk of engaging in further violence. 2, the vulnerability of anyone the individual has previously victimized or is likely to victimize in the future. And 3, the adequacy of alternatives to custody for mitigating the risk the individual may cause harm to others if he or she is not held in custody. Okay, so again, because obviously the sponsors of the bill I don't really think understand how the adversarial system works and the ethical obligations of everyone involved, let's break it down for you this way. You see, in every type of first appearance or bail hearing, and that's important to point out that these hearings occur sometimes well less than 72 hours after the incident. So all the information that you want the defense attorney to actually consider is probably not even available to the prosecutor at this time. But somehow or another, you think that we're going to be able to get all of this information to the defense attorney. But in this equation, you see, we have the prosecutor, okay? And then we also have the defense attorney, and then we have the judge, okay? Now, it is the prosecutor's job to proffer all of the types of things that this piece of legislation claims should be coming from the defense attorney. Because you see, it is the prosecutor's job to argue on behalf of what is most effective for community safety. As a matter of fact, the court rules, the applicable court rules, 3.2, CRR LJ 3.2, if you want to get technical on the district court side, and CRR 3.2 on the superior court side of things, basically spell out the same thing. There is a test by which everybody who's party to this hearing, the prosecutor, the defense attorney, and the judge, there are criteria in which they must consider to determine whether or not the release of the accused is proper, and if so, what conditions are attached to that release. And if release is not the proper thing, then what sorts of conditions, including the amount of bail that is to be set. It is all set forth by court rule. The adversarial system clearly says that in this three-part system, what you're going to do is you're going to have this person, the prosecutor, argue for the most strenuous and strictest of conditions, basically arguing for confinement. And this side is not only constitutionally mandated, but ethically mandated and mandated by the oath that we took when we became lawyers to argue everything that is legally and ethically possible on behalf of the best interests of the defendant. There is no other way to cut that up. That is exactly the job they have to do. And have I found myself as a defense attorney making arguments in court that I personally did not believe it, but I knew that legally and ethically these arguments were in fact possible and they were in the best interest of my client? Absolutely. If I had $1 for every time I had to do it, I'd be retired already. But ultimately, the problem that you have here is that no matter what this side says, or no matter what this side says, it ultimately is this person's job to make the decision. And so the problem you're having is not with the prosecutors, because I can assure you, prosecutors don't go to court and just go, whatever, judge, low bail's fine. That's not what they do, okay? And defense attorneys, and most often we're talking about public defenders, who are just making arguments flying by the seat of their pants. They probably met their client like 3 hours before this hearing now. They are coming up with good arguments because they're good seasoned trial lawyers, but at the end of the day, the quality of the arguments matters far less than what the judge believes should be the proper equation for determining what is in the best interest of community safety. And the problem you have, Washington State, is not with weak prosecutors, and it's not with super creative defense attorneys. The problem you have is with the judges. But if we go back to this three-part equation one more time, and let's just say for the sake of this hypothetical, both the prosecutors and the judges are weak, okay? Well, guess what? This person, the prosecutor, protected by sovereign immunity. Oh, and the judge, as we all know, because we've been talking about that lately, they're protected by sovereign immunity. But you see, the defense attorney over here, especially if they're a private attorney, well, there's no sovereign immunity there for them or the public defender. And so what this bill actually does is it acknowledges that there's a problem and acknowledges that you can't do anything about the true creation of the problem. So we decide that what we're going to do is shift the blame over to the one part of the equation where you're basically saying that the attorney is now going to create liability for doing their job effectively. Oh, and then to make sure that you are absolutely positively trying to stick it to defense attorneys who are doing their job correctly, the bill also reads, no form of legal immunity may be raised as an immunity or defense to any action brought under this section, including without limitation any immunity or defense premised on that argument that criminal defense counsel has absolute immunity from liability when acting within the scope of their duties in defending or advocating on behalf of the criminally accused, or that immunity is warranted or necessary to protect defense counsel's role as an advocate or the administration of justice. I literally wrote the letters WTF after this section in my notes before I made this video. Why is that? You are literally saying that no immunity could come from the fact that the defense attorney did what they were required to do by the Constitution, by the law, and by the rules of ethics. That is literally what that section of the bill says. Oh, and by the way, is immunity warranted because this would have some kind of a chilling effect on the advocacy that we see in courts? Well, yeah, it will. It will have exactly that effect. Because now if you're a defense attorney, you're like, well, hey, with this judge, if I make the right arguments here, I might be able to do something really good for my client, which, of course, again, you are constitutionally, legally, and ethically mandated to do. But I don't want to make those arguments because, oh boy, I might be opening up myself to some kind of liability. And ultimately, what this bill really does is it doesn't affect so much private counsel. It affects a segment of private counsel. But this absolutely puts the crosshairs directly on the public defenders statewide. And let me remind the sponsors of this bill that right now public defense is suffering from an astronomical budget shortfall. They do not have the funding necessary to do their job. And in some counties, they don't even have the funding to actually ensure that the defendants in that county are getting the bare minimum constitutional guarantees. And yet this bill wants to take a real problem, recognize that, well, we can't do anything really about the causation, but we got to blame somebody. So let's go after the defense attorneys. Because that's exactly what House Bill 1891 does. So listen, are you guys trying to solve a real problem? You most definitely are. Have you come up with a solution? No, you haven't. No, you haven't. You haven't come up with anything remotely close to a solution. And as a matter of fact, what you come up with is a piece of legislation, candidly, that should be struck down by any court that ever reviewed it and would absolutely, positively, and without a doubt, having a chilling effect on the Sixth Amendment rights of the criminally accused. It would absolutely, positively having a chilling effect on the effectiveness of defense counsel statewide, and it would absolutely, positively be in direct violation of the rules of ethics that every one of us attorneys has to follow. Okay, so the bill has had its first reading. It has now been referred to the House Committee on Civil Rights and the Judiciary, and to be frank, especially to all the sponsors of this bill, the committee is exactly where this bill should die. Candidly, I think you guys would do yourself a service by just withdrawing this bill. I do think that you've identified a real problem, but you haven't come anywhere remotely close to coming up with a viable or even constitutional solution. Didn't enjoy doing this video, but ultimately, if we got bad legislation coming out in Washington, you guys need to know about it regardless of where it originated from. I hope this is the last time I got to do a video like this, because the other side, well, they are the gift that certainly keeps on giving. Listen, it is House Bill 1891. Candidly, I ask you to contact all your representatives and tell them to put this bill into the dustbin of history. We'll link it up down below so that you guys can geek out on it for yourself if you want to. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.